Labour issues have been in the news a lot this week, especially at Eskom, where workers are participating in an unlawful strike with serious consequences for the entire country. And today we are actually talking about labour issues on Legal Talk. And joining us is Jaco Hamman of Hahn Attorneys. Big hello to you, Jaco. How's it going?
Good afternoon, Jan. Good and you?
I'm good, thank you. Are you ready for today's Legal Talk?
Yes, I am. And like you say, it's one of those hot topics, again, that you've chosen. And I think people sometimes don't quite really realize what their rights and obligations are from an employee side as well as an employer side, especially if you've got maybe a smaller business that's not one of the big corporate. So I think it will be very valuable to your listeners.
Absolutely. Looking forward to hearing the answers, Jaco. Let's start with the first question for today, and that is, what should an employee do if he or she is dismissed from employment?
So in South Africa, if an employer dismisses an employee, that dismissal has to be substantially as well as procedurally fair. Now, when we talk about procedurally fair, it means that the process that is followed in this dismissal should also be fair. So in short, that just means that an employer can't walk into an employee's office and just shout at him, "You're fired." That would have the effect that there was no process followed. So that would be procedurally fair. And then depending on the reasons, it could also very well be substantially fair. But let's first talk about the procedural fairness. Now, in order to determine if the process is fair, there's a couple of things that one will need to look at. Now, the first one will be, was there actually a disciplinary hearing or a disciplinary inquiry that was held, as opposed to like the example that I gave, the employer merely walking into the employee's office and shouting that he should be fired. Now, we hear about a disciplinary inquiry and then we hear about a disciplinary hearing. And sometimes there's a confusion about these two terms. And the question comes up quite a lot to say, well, what's now the difference? Now, there is no difference. It's actually exactly the same thing. Now, some people just call it a hearing and other people call it an inquiry. The legislation actually talks about an inquiry and says there has to be inquiry that the employer holds in order to determine whether or not the employee is guilty of that what he or she is charged with. Now, I think that we talk about hearings in the everyday life because it tends to be sort of as a hearing, although a lot less formal, having a specific court process where it's criminal law and you're being accused of murder, or it's a civil case in one of the courts in South Africa. So that it's in essence the same thing. So that has to happen. There has to be that formal hearing. And then the next thing to determine for the fair process is whether the employee was given notice that disciplinary hearing or the inquiry, like we spoke about, when that is going to be held. Now, on that, to determine if the employee was given adequate notice, one will look at two things in essence, two things, but the first one will be, does the employer have a disciplinary code or a policy that regulates how these things do or not? So if the employer has such a policy, then in that instance, the policy will determine what the number of days are that should be given. If there isn't any such policy, then what we normally use as a yardstick, if you'd like, is to say 48 hours beforehand, and preferably as well work days, but if not necessarily. So technically, if you give the person a notice on a Friday, you could hold it on a Monday, but then it will depend, whether or not the employee is able to actually prepare in the over the weekend for that specific inquiry. Some of the other things that one needs to look at is to inform the employee further of his rights during that inquiry. And one of those rights is that he may be represented either by a fellow employee or a recognized trade union. Now, a recognized trade union, sometimes people believe that if they see the word represented by a union representative, they think that they can go out and approach any union, pay their fees, and then the union can represent them at the disciplinary hearing. Now, unfortunately, it doesn't work like that. So in order for a union to be recognized by an employer, the rule is that there has to be 50 plus 1% representation of that union at the employer. And what that means is that, for argument's sake, the employer has 100 employees that work for him. 51 of those employees are being represented by Union X, for argument's sake. Then, if they are represented by that Union X, then the employer will enter into an agreement with that trade union, and then the employer will recognize that union. And that is the instance where one of those union representatives can then represent the employee at the hearing, or of course you can ask a fellow employee to represent you. Now, in some instances, an employee will come with an external representative, either an attorney or an advocate or even maybe a HR consultant or something like that effect. But technically speaking, the employer will be entitled to refuse that representation. And the reason for that is simply to say, look, this is the informal process. We want to handle it in-house. The employee does have a right of recourse after this inquiry or hearing, and therefore it's not allowed. Now, the case law determines that you as the employer have to listen to the employee or then his external representative when they ask for that representation. But the courts or the CCMA or bargaining council won't necessarily, and mostly they don't, interfere with that decision on whether or not to allow external legal representation. All that they are saying is they're saying, you, Mr. Employer, you need to listen to the reasons why this employee feels entitled to legal representation. Now, again, the company's policies will determine if or not that extra is allowed. So certain company policies go a step further and say, yes, external legal representation is allowed, but others don't. Now, if we talk about this disciplinary policies, those policies will also set out what other processes the employer has to follow. Now, if the employer doesn't follow that process within his hearing, then that can, of course, also be procedurally unfair. And it's very important to remember from both the employer and the employee side that if the employee is dismissed and the employee approaches the CCMA or the bargaining council, found that that the process wasn't fair, so there's no procedural fairness, that employer can be directed to pay up to 12 months' salary of that employee for just not following the right process. So even therefore, if you've got all the evidence in the world that your employee has stolen R1 million from you, argument's sake, if you do not follow the process correctly, you can still be fined to say, well, because you didn't follow the process, therefore you have to pay 12 months' salary to the employee. So that's a very big risk, and that's why it is so important for employers to follow a fair process so that you don't come with a later stage where it's found that your process was procedurally unfair. Some of the other things that you have to remember during the process is that that after the inquiry, the employee communicates his decision to the employee and then preferably give them written notification of that decision. and then inform them what their further rights is. For argument's sake, they can appeal it to somebody higher within their organization, or take it to the CCMA or rather the bargaining council. And again, these things are normally set out in the policy of the employer.
Jaco, next question: does an employer have to have a disciplinary policy?
So that's very good. And we've spoken a lot now about disciplinary policy. So the short answer is no. The employer doesn't have to have a disciplinary policy. So it's not mandatory. It is good, however, to have a policy, especially if you've got more than anything between 5 or more employees. And the reason for that is that then whoever conducts, or whenever there's something happens that the employer is not happy about, then he can go through those guidelines or that policy and work through it to see exactly what he or she should do as the employer representative. So that's why it's better to have a disciplinary policy, although it is not mandatory to have one. What is very important is that if you have a policy, then you have to stick to that policy. Then you can't. So, for argument's sake, the policy says you have to give the employee 5 days notice of the disciplinary hearing. Then you can't give the employee 3 days notice, because then you're contravening your own process that you've set up. Now, let's say now, for argument's sake, before I get to that, let's talk about substantial fairness. So we've spoken now briefly about procedural fairness and how we should deal about that. Now let's talk about substantial fairness. Now, substantial fairness means that if one looks objectively at the evidence presented, whether that evidence presented on a balance of probabilities will leave one to believe that yes, the employee did in fact or is in fact guilty of the alleged contravention. Now, we've probably all heard about these two different ones. On the one hand, you've got a balance of probabilities, and on the other one, you have a beyond a reasonable doubt. Now, beyond reasonable doubt is applicable in criminal matters. So when a magistrate or a judge needs to decide whether somebody is guilty of murder, let's take that, or culpable homicide, he must or she must look at the evidence and then determine whether, based on that evidence, beyond reasonable doubt, the person committed the crime. Whereas in civil matters and including labor matters, it's on a balance of probability. So to give you an example, you now have evidence that a pen went missing, for argument's sake. And the evidence that you have is somebody that saw two people going into the office and leaving out of it. Now, without a reasonable doubt, your level of evidence that you have to have is a lot higher. So, because nobody can have any doubt whatsoever that it is person one that took that pen. Versus in labor, on a balance of probabilities, one can sit back and say, well, you know what, there might be this or that, but most probably it was person A that took the pen. And if that is what you can prove, then you'll be fine. Now, if, on the contrary, there is no probability that it was person A that took that pen, but you still find the person guilty, then it will be substantially unfair. Now, what happens is that employees now dismissed, the employee is aggrieved, they go to the CCMA or the bargaining council, then we call it a trial de novo. What that means in essence is that hearing or then inquiry is held afresh in front of this CCMA commissioner. So this commissioner will then look at the evidence that is presented in front of him or her on that day, and then based on that evidence determine whether or not the employee is guilty or not. And if he then finds that no, the employee is not guilty, but in fact the employer found him guilty, then what the commissioner can do is either order the employer to pay, again, up to 12 months salary of that employee, or can even order the reinstatement of that employee. Now, the reinstatement, however, will be determined on whether or not the trust relationship between the employer and employee is broken. But I can keep you busy with that also for another 20, 30 minutes just on that alone. So maybe let's, for purposes of now, just move on. What I just want to say is you've heard me now talk a lot about the CCMA or the Bargaining Council. Now, most of our listeners would have heard about the CCMA, and that if you're dismissed, you go to the CCMA. However, it all depends on the industry that your employer or you then, whilst you was employed, was in. Whether you go to the CCMA or the Bargaining Council. For argument's sake, a teacher, that works for the government. So they're a government employee, they're a teacher. So their Bargaining Council, which operates similar to the CCMA, it's got its own set of rules, but it's more or less the same as the CCMA would be. They would go to what is called the ELRC, the Education Labour Relations Council. And then the ELRC will look at that dispute of theirs and then settle it. Now, in the CCMA, there's a process. You've got your conciliation, your mediation, and arbitration. And the first two, in essence, is to see whether or not you can't get the parties to agree on the proposed way forward. Either say, well, okay, yes, I'll pay this employee 3 months, and the employee says he's happy. We don't have to go in front of the commissioner, and then they settle it. If the parties can't settle it, then they go on to arbitration, and that's when it starts. Now, just on the substantial fairness and going back to the procedural fairness as well, and to explain to the listeners what the arbitration will be at now the CCMA or the Bargaining Council, is your employer will first represent its side of the story. So it will call its case and have its own his own witnesses. Then the employee can cross-examine those witnesses. Now, cross-examination basically means that the employee can now ask the witnesses of the employer any questions relating to that, what they have testified on. So if I am now the witness of the employer and I say, yes, I saw Mr. X walking into the office, then the employee technically can't ask the witness questions about 3 or 4 days earlier to that. He should stick to the portion of what that witness testified. However, that being said, the whole way that disciplinary inquiries within the workplace and even in the CCMA to an extent has been set up is to keep it as informal as possible. So yes, there are certain rules that one has to adhere to at the end to get to a fair hearing, but the CCMA won't look at the process and say, well, you didn't exactly stick to this rule or exactly to that rule, because there's case law to say one has to keep it as informal as possible. So going now back to the process, you've got your employer who calls their witnesses, the employee who then cross-examines, and then the employer can redirect again, in other words, ask questions. And then it's the employee's turn, and the employee will then, of course, call all their witnesses. So that in essence is what the process is, and substantial fairness. On the substantial fairness, what I would just like to highlight is I had a case the other day where an employer dismissed an employee, and the allegation was that this specific employee received money from new prospective employees in order to get jobs. And whenever they did something wrong, he would extort money from them in order that he doesn't report it. Now, the employer had one witness that the employer called during the testimony at the in-house hearing, as well as during the CCMA hearing. Now, the challenge with that witness was that witness was dismissed as a result of testimony that the first, let's call him for what the first employee, and forgive me for a moment, but if we call him the accused for the moment, that as a result of that accused testimony, he was dismissed. So the commissioner in that instance said, but that witness isn't a reliable witness. Now, during the disciplinary hearing at the company itself, there were other witnesses that was called, and there was written statements. But what the employer did wrong is that during the CCMA hearing, which, remember I said it's a hearing afresh, a trial de novo, the employer didn't call those other witnesses, nor did they present those other testimonies. And the witness of the employer, there was no recording of these guys being called at that hearing. So the challenge was that at the disciplinary hearing at the CCMA, that testimony wasn't in front of the commissioner. And that resulted in the commissioner finding that, in fact, that dismissal is substantially unfair. So employers have to make very sure that the evidence that they have is sufficient to, on a balance of probabilities, find somebody guilty. And then, even if they have that evidence during the inquiry itself in-house, that they should have that information at the CCMA or then the bargaining council. So those things are very important. And I think just lastly on the subject is, whenever you're in a situation of a disciplinary action that you want to institute against an employee, make sure of the processes that you need to follow. Make sure of your evidence, how you should do it, because these things can cost one a lot of money. I said to a client of mine the other day, who is a fairly new client, and when he phoned me, he didn't follow any processes whatsoever. And this employee stole a lot of money from me. Now, I said to the client, I said, now you're going to lose twice. So the first time you lost because this guy stole from you, and now secondly, you're going to lose because you didn't follow the right process. So making sure that you engage with somebody that's got the necessary know-how and that these things are right, so that you don't sit with a situation where these things cost you money. And from an employee side, if you feel that you've been unfairly dismissed, either procedurally or substantially, go to the CCMA or the bargaining council.
Jaco, in closing, what can an employee do if they realize that an employer is not paying over their UIF payments?
Yeah, so the UIF is the Unemployment Insurance Fund. Now, in terms of the law, the employer, whenever he's got an employee who is employed for more than 24 hours a month. Now, if you do your math, that will mean 3 times 8, which is 24. So if you employ, for argument's sake, a gardener, and that gardener only comes in once a month, once a week, but for 6 hours or 6 plus hours, because there has to be more than 24 hours, that employer has to register the employee with UIF. And then how it works is that monthly contribution is 2% of the worker's gross salary, and you must deduct 1% then of your worker's gross salary per month, and you as the employer then contributes the other percent. Now, what we found over the years that sometimes happen when employers are struggling financially, they deduct the money of UIF. There's other things that they do as well, deduct and then don't pay over. This is now specifically to UIF. Now, and then when the employee loses their job and they want to claim UIF, they realize that they're not registered. Now, what the employee should do if he realizes that either he's not registered at UIF or he's registered and is being deducted, but he realizes later that his money hasn't been paid over, then in that instance he should go to the Department of Labour and lay a specific complaint. The Department of Labour will then launch an investigation and they will then take it further.
Very, very interesting. Jaco, thank you so much for your time and your knowledge today. How do we get in touch with you?
Well, you're welcome to go and have a look at our website. It's www.hahnlaw.co.za. That is HAHN law.co.za, and all our contact details are on there.
Jaco, thank you so much, and wishing you a wonderful day. Until next time.
Thank you very much. You'll enjoy the day.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations, and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.